there is no defendant in the. I'm the defendant in the case. Am I the defendant in the case? There's no victim. There's no victim to my crime. Correct.
You have drug charges: possession of methamphetamine, possession of paraphernalia, and driving while suspended are your 3 charges.
Yeah, but no victim.
Okay,
Today's case features a
issued
sovereign
bench warrant
citizen
bond
whose
forfeiture
courtroom behavior quickly raises eyebrows.
and set a
He
new
appears
bond in the
confused
amount of
about basic legal
$10,000
proceedings
cash or
and
surety.
even seems unaware that he is the defendant in his own case, which makes the situation especially
Are
surprising.
you still
Walking
representing
into a
yourself?
courtroom without understanding your role in the hearing
Yes,
creates
sir.
immediate tension and sets
Do you
the
want to
tone
continue
for what
representing
follows.
yourself?
While his arguments suggest a serious misunderstanding of how the
I'm
legal
not looking
system
at-
works,
I'm looking at the
it is
paper.
important to approach the situation carefully
Yes,
and
sir.
avoid jumping to conclusions about his circumstances. The exchange
Don't have any
highlights how
money to-
unfamiliarity with legal procedures can lead to
Pardon?
awkward and
I guess
uncomfortable
I'll
moments in
represent myself.
court. As the hearing
You understand
unfolds,
that if you can't
viewers are
afford
left
to
forming
hire
their
an
own
attorney,
opinions
one would
about
be
his
appointed
actions
for you.
and level of awareness before the full picture becomes clear.
David Walker.
Your Honor, it looks like he has 2 files.
I see that. All right, we'll next take up 2 cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day?
It's safe for sure, sir.
Okay, well, I issued a bench warrant bond forfeiture and set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
You want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I'll represent myself.
Okay, you understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
Okay, well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that he's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel, and then he had a failure to appear. And on May 5th, we did not appoint any counsel. I don't show an actual waiver. And the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
Okay, well,
Okay.
Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right, can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There is no defendant in the. I'm the defendant in the case. Am I the?
It is understandable why some viewers
In
might
front of
feel
me on
confused by
July
his behavior during the
17th.
hearing. After being offered legal counsel at no
For your
cost,
preliminary
he
hearing
chose to
control
decline it
docket, where
and
were you
proceed
that
on his
day?
own. He was then presented with paperwork explaining the risks of self-representation,
Safe for sure, sir.
yet he appeared
Okay,
unsure
well,
about
I
something
issued
as
a bench warrant
fundamental
bond
as whether he
forfeiture.
was the defendant in the case. That
and
moment
set a new
especially
bond in the
stands
amount of
out because
$10,000
understanding your
cash or
role in the
surety.
courtroom is one of the most basic aspects of any legal proceeding. The situation raises questions
still
about whether his
representing
statements are
yourself?
part of a broader sovereign citizen strategy
Yes,
or
sir.
simply reflect a
Do
genuine
you want to continue
misunderstanding of the
representing
legal
yourself?
process. Walking into court while in custody and seeming
I'm not
unaware
looking
of
at
your
you, I'm
position
looking
in
at
the
the thing.
case makes the exchange even more puzzling.
Yes, sir.
Regardless of the reason, the interaction highlights how risky
Don't
it
have
can
any
be
money
to
to.
represent yourself without a clear grasp of.
Pardon?
There's no victim. There's no victim to my crime, correct? The crime that I'm accused of, there is no victim in the crime.
The state of Kansas, you have drug charges, possession of methamphetamine, possession of paraphernalia, and driving while suspended are your 3 charges.
Yeah, but no victim, correct? No victim in the crime. No victim.
I'm not sure I understand your question and what that has to do with your waiver of counsel.
Well, I'm the defendant. There must be someone making a claim
The state of Kansas is making the charges against you, Mr. Walker.
the state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself or do you wish to have an attorney representing you?
I will represent myself.
You've got a waiver of counsel in front of you, correct?
Yes, I suppose so. Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you. And that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game
in front of me on.
It seems like the court is allowing him to
Yeah, it
place
looks
his
like he has
questions
2
on the
files.
record, even though
I
some
see
of
that.
them are surprisingly basic, such
All
as
right, we'll
asking
next
whether
take
he
up
is
2
currently
cases, both
incarcerated or
entitled State of
confirming that the
Kansas
person
versus
presiding
David
is the
Wayne
judge.
Walker,
Moments like that make the
22
exchange
CR
feel unusual
398
and
and
raise
22
questions about what
CR
his approach might
508.
be. Some
All right, we'll
observers
first
might
take
wonder
up
whether he is
22
intentionally
CR
acting confused as a
508.
tactic,
This is my
possibly
case,
hoping it
Mr.
could help him
Walker. You
later
failed
if
to
he challenges
appear
the outcome. There is a legal concept
in front
known
of
as
me on July
ineffective assistance of
17th
counsel, which applies when a defendant's attorney
for your
performs
preliminary
so
hearing
poorly that
control
it undermines
docket.
the
Where were you
fairness of
that
the
day?
trial. However, that claim generally applies to representation by a lawyer,
For sure,
not to
sir.
situations where
Okay,
someone
well, I
voluntarily
issued a
chooses
bench
to
warrant
represent
bond
themselves.
forfeiture
Because he declined legal counsel,
and set a
any
new bond
confusion
in
on
the
his
amount
part
of
would typically be
$10,000
his own
cash or
responsibility.
surety.
Still, his behavior leaves room for debate about whether he is deliberately trying to create an
Are you
appellate
still
issue
representing
or simply
yourself?
lacks understanding of courtroom procedure.
Yes, sir.
The situation makes it
Do
difficult
you
to
want to
determine his
continue
intent,
representing
and
yourself?
viewers are left weighing whether his actions are strategic or stem from
I'm not
genuine
looking at you, I'm
confusion.
looking at the
October,
trying to understand.
Mr. Walker, your case is being set on October 10th at 2:30 in front of myself. And that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You've got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I would be able to have access to certain legal things to be able to put my case up.
I believe they've got a law library there at the jail. I'm
Oh,
not
they
sure
do?
what kind of access they provide to you, but you can consult with somebody there at the jail.
Okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case. Looks like you failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm gonna set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is 6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
All right, we'll be in recess. Mr. Walker, you are excused. Thank
It appears unlikely that he will be released anytime soon, especially
I
after
don't know what he
declining
would
the
do for me.
opportunity for free
you.
legal
Well, he could
counsel.
provide you
Although
legal
some
advice and
individuals who
perhaps
identify
advance
with
any
sovereign
defenses you
citizen
may have had,
beliefs
but if you
strongly
want to
distrust
represent
the court
yourself, you have
system,
that right.
refusing
I just
available
want to make
legal
sure you
assistance can leave a
understand
person in a
that if
far more
you
difficult position.
can't afford an
Even if
attorney
someone
and would like to
questions the
have one
court's authority,
represented you,
the
I
legal
would appoint
process will
one
still move
for you.
forward,
Do you
and
understand that?
navigating it without guidance
Yes,
can
sir.
be extremely
And
challenging.
you wish
In
to
many
continue
cases,
representing
defendants who
yourself?
choose to represent themselves
Yes,
can
sir.
request standby
The
counsel,
docket notes
an
don't
attorney who remains
reflect if
available
a
to provide
waiver of
advice if
counsel
needed.
was ever
Accepting that kind of support can make a significant
signed. Do you
difference,
have any notes
particularly
that
for
would
someone
reflect that
unfamiliar with basic courtroom
he's
procedures.
waived counsel
In
on
this
the record
situation,
or
he
otherwise,
rejected
Ms.
help
Norris?
and then struggled with
Your Honor, I
fundamental
just note that
aspects of his
on
own
December
case,
30th
which only
of
made the hearing more
2022,
complicated for him.
defendant stated
While
that
it
he
can be
would hire his own
frustrating or
counsel,
puzzling to watch,
and then he had a
moments like
failure to
these also
appear.
highlight how important it is
And
to understand the consequences
we,
of legal
and on
decisions.
May 5th, we
The
did
justice
not
system
appoint any
proceeds
counsel.
according to established
I
rules,
don't
regardless of
show
personal
an
beliefs about
actual
jurisdiction or
waiver,
authority. Ultimately, the hearing serves as
and
a
the notes
reminder
don't
that having
reflect
proper
that he
legal
did a
guidance
waiver
can
on the
greatly
record. It just
affect the
says that he
outcome of a
would
case, and
hire
declining that
his own
assistance
attorney.
may lead
Okay.
to
Well,
avoidable
Mr.
setbacks.
Walker,